one or two faces also. Anyways, Purva, you from Amity, you are looking forward to learn drafting of contract. As we are going to be lawyers and we are going to draft it, absolutely. Okay, cool. So let's move ahead. Thank you, Adya. I can see you. Sadhna and Rita, I can see you. So let's start the drill. Yes, Sumit, it's a critical step. We will talk more. Let's first stick to the session and let's see what we can do at the end of the session. You guys have to give me a prompt if you can see my screen. Somebody will have to tell me a yes, no.
Yes, ma'am. Yes, ma'am. Yes, ma'am.
Thank you so much. So we learn the basics of contract drafting. But when we are supposed to learn the basic of contract drafting, the first thing we need to talk about is the Contract Act, right? So do you see the Contract Act dates back to 1872? It's a pre-independent contract. And do you guys have any idea how many sections are there in this, Bear Act, which you see, which is so, thin? Do you have any idea how many sections it has? Anybody would like to write in the chat? I will get the prompts from the, host. So if you guys feel like, can take a try. In the meanwhile, do you also know that earlier when Contract Act, the Indian Contract Act was brought in 1872, Sales of Good Act and the Partnership Act were a part of the Contract Act. But later on, they are separated. Now you will not see a Contract Act with Sales of Good Act and Partnership. You'll find different Bear Acts. So if you go and buy books, they will come in separate books. Now, guys, even if you have drafted contracts, today this will bring a lot of clarity of what I'm going to tell you. That when you're sitting with a part of a contract, with a contract draft, or you're about to draft something, it is very important that you categorize it or break it into these four parts. The first part is the introductory part, which will need a few of technical details which will come from both the parties, such as the name of the party. These days we also put in the phone number, the email ID, the PAN number, if it's a company, GST number, CIN number. Why all of these so many relevant details? Just to identify the parties in a better way. If ever there is a glitch, if ever there is something which is gone wrong between two parties, then you have sufficient information to find them and identify them. Then introduction always begins with the title of the agreement, and if the title of the agreement, such as what I mean by title of the agreement is say a master service agreement, an employer-employee agreement, a website development agreement. So the title itself will tell you what is going to be inside the agreement, right? The moment you see the title, you get a clear idea, okay, this is in relation to this. What are recitals? Recitals is the history which has brought in together this contract. Why? So what is recital? Say like I meet Shreyanshu and we decide that okay, I can give you this services and he's ready to take that services. So this discussion, which I just said, becomes the recital of your contract. And definitions. Definitions are very important. So like I am Rachna Shorff, and then there is Shriyanshu Tripathi. So Shriyanshu is ready to take services from me. So I am the service provider and he's the service receiver, right? So if we define this, then the entire contract is between these two parties, right? So you don't have to again remember and say Shriyanshu and Rachna, Shriyanshu and Rachna. You can just say the service receiver, service provider, service receiver, service provider by first defining it in the definition section. Yeah, that is why definitions are so important. Definitions usually consist of the most important words that will reappear in the agreement again and again, or it requires a definition to be understood by the parties at large or by anybody who opens that agreement. That is introduction. Then the other part can be seen as the operative part of the agreement. That is, what do you mean by operative? Where it reflects the intention of the parties of why have they come together. They are such as rep and warranties, term of payment, term termination, and exclusivity. We're going to look into details, so I'm not speaking about them here. Boilerplate is the what if clauses. What and how would a situation would be dealt if something happens? So force majeure. In COVID times, this is one was the most important clauses of the agreement, which for years or you can say for decades was never looked into. Yeah. Similarly, is limitation of liability, notices, indemnity, governing law and jurisdiction, dispute resolution, confidentiality, IPR, and and the last part, which is again very important, is the annexures and the schedules and the attachments that you make to the contract, which completes the contract as a whole. So, if you can divide your contract in these four parts, you will have, an eagle-eyes view to catch any ambiguity or to catch anything which needs to be taken care of. Now, this is so important to understand of what I'm just going to speak, that our contracts and agreements same. Yeah, we use this word so commonly, and we think okay they mean the same. Yeah, and we also have that question in first year when they teach us the Contract Act. They ask us are all contracts agreements or all agreements are contracts? Explain the statement, and this is one of the most important question in the 100 marks paper. Yeah, but it is actually very important also in your practical life as a lawyer. So let's start this with an example for you. Say today I tell Rita or I tell Sadhna, hey Sadhna, I got an iPhone. Would you like to buy for 30K? Sadhna says, okay, cool, I'll buy it for 30K. So what does here happens? I gave her an offer. Would you like to buy? And she accepted it. Right? The moment there was an offer and there was an acceptance, it becomes a promise. Okay. And now, was there a consideration in this promise? So I said for 30K, right? For 30,000 rupees. So yes, what is consideration? The monetary value attached to it. So yes, in this promise there was a consideration also. So when there is a consideration in a promise, it becomes an agreement. But when does an agreement become a contract? When it is enforceable. Now, what does the word enforceable means? So, the word enforceability in very simple language means which can be enforced, which can be claimed, for which you can move the court, for which you can go to the court. That is enforceability. And any agreement from offer to acceptance to promise, when these three steps are completed, becomes an agreement. And when it is becoming enforceable, it turns into a contract. So, now to make it enforceable, there are certain conditions which are laid down under Section 10 of the Contract Act. Again, let's take an example. See, today you go to buy a TV. You go on Amazon, you choose a TV of your choice, you order it, you pay the money online, and now the television does not reaches to you. So can you go to the court and either call Amazon and tell them that hey Amazon, pay my money back or pay me the product, give me the product, or can you go to the court and ask the court to pass an order in your favor and ask them to either give your TV or refund the money? Yes, you can do it. Because the agreement between you and Amazon is enforceable. Means there is an intention to create a legal obligation. Say today, you tell your younger siblings that hey, if you do well in class 12 exams, I am going to give you an iPhone. Now your sibling does very well in the exams, and then he or she comes and tells you, hey, you had promised, now give me my iPhone. So you say, hey, wo to maine aise hi bola tha, I was just kidding around. So is this legally enforceable? No, right? It is just a social thing, right? It is, there's no intention to drag somebody to the court or to claim something out of somebody, right? So when does it becomes enforceable? When there is that intention to create a legal obligation. Offer and acceptance may have happened, but is there that legal obligation? So this is also one of the conditions to make it enforceable. Okay. Another is it should have a lawful object. What does a lawful object means? Lawful object means that something which should be lawful. Today, somebody comes and puts me on gunpoint and says, you know, or say, let me take another example that I am ready to pay some money to somebody for giving me a leaked exam paper. Yeah. And I have paid that money already to somebody, but that didn't get that leaked exam paper. So is that person going to move the court? Is that person eligible to go to the court and seek that amount back or ask the court to enforce it? No, right? Because it was not lawful. The object behind, the motive behind it was not right, right? That is what is lawful objection and consideration. It must be there present to make it enforceable. Next, it's that the parties to the agreement who are trying to create a contract must be competent parties. What do you mean by competent party? That it means that you are a sound mind person. It means that you above the age of 18. It means that you're not disqualified by law or you're not in age. And fifth is that should be free consent. It cannot be under undue influence, mistake, coercion, fraud, or misrepresentation. It means that you're willingly entering that contract. Yeah. So if these five important parts are there, then it turns from an agreement to a contract. Then it is enforceable in a court of law. Now, since we have understood the basic, let's dive deep into what all clauses is usually, or 90%, or you can say 99% is always there in any kind of contract, without which a contract cannot be drafted, without which a contract will not find its sense, or which will lose its meaning in total. Okay. So first is I want to explain about representations and warranties. So what is representation and what is warranty? Representation is facts. Say today I'm a mobile shop. There are certain facts about that mobile shop, right? That that the mobile shop has a right to sell that phone. The mobile shop, if it is displaying certain advertisement, it is true. Then there are certain warranties around it that the manufacturer who has manufactured that phone uh, is giving you a certain warranty around your phone, is taking certain promises around it. So this is an example of representation and warranty. If you want to simplify it for yourself for your entire life, always remember representation means representation of facts, of what you are. You are means of whoever you would be drafting it for, who that person is. Is the person a service provider? Is it a brand agency? It's an organization who's taking some services from the other. So your representation should be very, very clear of what you are, what are you going to do, and what do you do actually. And similarly for the warranties, the guarantees that you're promising out on the basis of those facts. Yeah, these clauses are can be said to be turning point for your agreement also. Yeah, when there are if any legal conflicts, the lawyers do return back and see what were the representations in the warrant. Because if you're today saying that, hey, I am a mobile company, I promise to sell this version of mobile, I promise to say that, the advertisement that I'm going to give a 30% discount is true. If I'm making that as a fact and giving out a warranty around it, tomorrow you will not be able to deny it because that's your fact, that's your very existence. Moving further, another clause is the indemnity clause. Indemnity means to protect yourself. So when you are, say, you are, say, for me, since I'm a gaming company lawyer, so I'll take an example from there. So my organization is ready to get certain services from a brand agency company, right? Now, I have to protect myself because my brand is very big, right? And if that brand agency to whom I'm, hired through this contract to give me a lot of services to bring my brand at a higher level, and it does something which is grossly wrong, and my brand value decreases, then it can be very damaging for the organization. So in that sense, this indemnity clause will come to my become my savior. So what does it literally means? Let me first read it for you. One party promises to protect the other from lawsuits and other claims, to hire and pay lawyers for pay for judgments or settlements. And these kinds of find it for software, cloud services. Yes, of course, in tech law, you definitely find an indemnity clause, but indemnity clause cannot be ruled out. One of the most basic clauses, one of the most important clauses. Wouldn't you want your organization, or if you're freelancing, your client to be protected if there is something which goes wrong from the vendor side, from the other party side? That is where you need an indemnity. That, hey, we are entering into a contract, you better secure me if something goes wrong from your side. Yeah, that is what an indemnity is. It is like during the time of the contract we are in, we make sure that we see this risk, and we as lawyers are supposed to do that. That's the legal acumen, that's the legal value that we are adding, right? That you make sure of your client being taken care of. You put this clause foreseeing that if something goes wrong, where can your party come back and save itself? Yeah. So, for example, say contracts often have an intellectual property. So indemnity from the vendor, for instance, that's because the customer buys a risk of IP litigation just by using the vendor's technology. So today, say my HR team uses a tool for all its employees. Okay, the moment it uses a product from a vendor for all its employees, it has onboarded some particular kind of tool or software. Now, the moment it brings that tool on its system, it has a risk of that vendor's IP. Its IP can be its logo, its dashboard, anything. Yeah, the projections around it, everything. So to protect itself from there, yeah, when it comes from the business and the technology, it better seeks indemnity. Yeah, so it saves itself, because here if I've taken that tool from a particular vendor, and I don't have any intention to harm that particular vendor, but something goes wrong in their intellectual property without me even being aware about it, then I go and seek my protection under indemnity clause. That is where I protect myself. Is this clear to you guys? I want to hear. Can you guys write?
Yes, ma'am, clear.
Okay. Any questions do we have till now?
Yes, ma'am.
I did change the slides. Did you see the changing slides? Do you guys have any question? Am I audible?
Yes, ma'am. The slide is loaded. Yes, ma'am. Yes, ma'am.
But do you guys have any question?
As of now, no, ma'am.
All right, great. So is my screen getting delayed for you guys to view?
Yes, ma'am.
It is? It's black here because I've stopped it at the moment. Now tell me if you guys can see it. Wait, let me. You guys should have told me that you can't see my screen. Now tell me, can you see my screen?
Yes, ma'am. Yes, ma'am. Yes, ma'am.
Okay. So every time I move to the next slide, I'm going to say I'm moving to the next slide, and if you guys can't see the next slide, please prompt. Okay. The slides are for you guys. So moving ahead, if we look at an example of an indemnity clause, so this is how you will find it in maximum of the agreements. Indemnity, it says indemnitor shall defend and indemnify the indemnified party. So who's the indemnitor? the one who's protecting. Shall defend and indemnify means to protect. Indemnified party means the one who is being protected. And it's indemnified associates, which can be anybody as they would like to define it, against any indemnified claim, which can again be defined or not be defined. That's absolutely on one's discretion. Indemnitor's obligation set forth in the preceding sentence includes retention and payment of attorneys and payment of court costs, as well as settlement at indemnitor's expense and payment of the judgments. So that's what happens when the indemnifier indemnifies the indemnified party. So that what's happened when one party promises to protect the another. And how does it protect? It protects by paying certain costs, making certain payments, retaining something, getting judgments. Yeah, that is what an indemnity clause will look like. And yes, mind you, you should always make sure that indemnity is from both the sides. Until and unless the scenario is different, you will have to understand the nature of the business. But it is always recommended that indemnity should not be one side. Moving forward, another very important clause is means these clauses which I'm speaking about, you cannot complete an agreement without these clauses, hence they are here. Limitation of liability, this is also known as the dollar capping clause. Means, as the name says, limitation of liability means you limit your liability. See, today again I'm going to give you the same example, but it will vary in terms of this clause. I'm a gaming company. I need a brand agency to market myself, to increase my brand value, right? I'm hiring that person, say, for a crore for a year, okay? But my brand value is much more larger. If the brand agency does something wrong, if I'm paying him, you know, crore divided into 12, whatever that amount comes for, but if my brand is hampered, I may be facing a damage of more than maybe 30 crores, right? So then where do I go? Here, of course, if I claim 30 crores and I'm just paying out 1 crore, the brand agency would not be able to pay, right? So it will have to limit its liability. That okay, whatever can be the scenario, and there is no ruling out that there can be mistakes, there can be negligence, there can be unintentional errors, and something can go wrong during the period of the agreement. But let's limit this liability. Then it becomes a part of negotiation when you as the lawyer for the company may negotiate with the vendor. The vendor may say that, hey, I will be maximum able to limit my liability to a crore that you're going to pay me for a year, not beyond this. I cannot. That may be the vendor's point of negotiation. And I might be saying as the lawyer for the company that no, my brand value, if you do something wrong on my website, I'm going to lose so many customers. Yeah, and if I put that in revenue, I'm going to lose some 30 crores, and you're saying you're just going to give me 1 crore. Doesn't work. So you better come up with some different number, that if anything goes wrong, I can ask you for liability and you can pay me off my damages. So that is where the limitation of liability clause comes. You should go and check out these clauses in different websites. There's some very funny clauses where they say we would like to limit our liability to the cost of rupee 1 or to the maximum that player has earned or in this particular year. Yeah, so it can be anything. You as a lawyer will have to take care. You as a lawyer will have to create that value, and you have to understand the business. If you understand the business for whom you're creating contracts, you can have them for a lifetime. They will never dodge you, because finding somebody who understands the business and then drafts a contract is, and it's a rare case. And now in this uh, chat GPT and AI era which we are moving into, people who have this acumen are going to even win over chat GPT. Yeah, because chat GPT will not try to understand all the businesses. It will not be able to give that fine tuning which you would be able to give, right? So hone your skills to that level that nobody can beat you, and that will only come with practice and practice and practice. There's nothing to be scared. I'm just sharing my experiences over the period of years and telling you that if you want to understand a clause well, look at a lot of different agreements and look at that one particular clause in different agreements. You will get so many ideas. You will also learn that how one clause can be written in so many variations. Yeah. So that's limitation of liability. I'll read it for you. Limitation of liability clause says that if one party injures the other, it's not liable for full damages. Limitation of liability can be a bit hard to swallow. That's true. In fact, court often won't enforce the clause if they think the customer did not grasp its importance, particularly if the customer is a consumer. So, if you go today, what do? You go and check out a website today and see the limitation of liability. You'll see it's written in big block letters. Why? Why it is highlighted so badly? Because they wanted to make it very visible to the people who are coming on their website. Yeah, so that the consumer cannot go and say, hey, I didn't knew about this clause before the court. That is one of the way for the organizations to protect themselves as well. The vendor wants to establish that if the customer didn't notice the clause or recognize its importance, it's the customer fault. That is why they're making it so bold and visible. Vendors should take other precautions to increase their chances of enforcement. Limitation of liability clause comes in two flavors. That's one word which I spoke of. Dollar capping is by dollar capping means when you cap it in terms of capping means just how what do you do when you put a cap on your head? What do? You cover it, right? You close it. That is what cap means. Dollar capping means limiting it by way of money. How much money are you going to give out if there is a claim on you? And exclusions of consequential damages. And exclusion consequential damages are not direct damages, they are special damages. So that is where limitation of liability clause can be invoked. Most contracts features both as overlapping protection. Yes, so if you will see a limitation of liability clause in the agreement, you will see that there are two three at least what should I say? One, two, three. Yeah, at least 2 to 3 paras to cover that clause. Okay. At the simplest part of the limitation liability clause caps the party liability at the role of. Explain this. Now, another important clause is the confidentiality clause. Why do you need a confidentiality?
Excuse me, ma'am.
Yes, please. Tell me.
Ma'am, please move the slides.
I did. Did you see that confidentiality clause? Is it?
Yes.
All right. Great. Thanks for telling.
Yes.
Thank you.
Thank you.
And somebody is on the mic. Can you put the mic off, please, for the time being? Rita, if you can hear me, help me out there, please. Thank you. So now let's look at the confidentiality clause. Guys, give me a shout out if you can see the confidentiality clause.
Yes, ma'am, we can see.
Yes, ma'am. Thank you. Thank you. So, confidentiality clause. See, what does the word confidentiality means? It means secret. Something which you want to keep it a secret. Something which you want to keep confidential. So now, again, let me give you an example. I'm a company, okay? Now I'm running a business and I have so I'm running a business of making tea and I make a tea which has a secret recipe, okay? So this is my secret process, right? I would not like it to be disclosed to my competitors, right? So, and I will have a few employees with me who will work with me, right? So I bind them by confidentiality clause, or maybe if I am converting them in my tea into some secret process and processing it and getting it manufactured, and I've given it to outsourced it to a manufacturing company. So that manufacturing company whom I have hired to do that, yeah, I have to bound him by confidentiality that hey, you know my trade secret, you know my process of the secret behind my recipe. So you cannot go and tell the world at large, right? That is confidentiality clause. That is the work of this clause. That in the duration of the business that we are doing, the duration of the contract we are whatever I tell you about my business, or maybe you even tell me something about your business, or you share something which is confidential, we both bind each other. Or if it is only one side, then the one side binds the other side, that you cannot go and disclose this. That is what the confidentiality clause. And this is, without this clause, I don't think businesses can move ahead. And it is not only in the industry which we know of. Whether you see the movie industry, you see the fashion industry, you see any industry, and if there is an agreement around it, it will have a confidentiality clause. Yeah? And these clauses are not negotiable. These are usually very tight compartment clause. Yeah? Where you are just bounded. So if you are working with a company, you will know, as legal, you will know so many things about it. Yeah, if you're in their in-house, or maybe even if you freelance, you will know so many things about them, but you are bounded. You cannot go and disclose it. Yeah, or you cannot use it against them. That is why there is a confidentiality clause, and that is the power of confidentiality clause. See, I am telling you the in-depth nature. If you know that what this clause means, what its purpose is, what is supposed to bind, then drafting is not a challenge. Then you will, even if you go and check the internet, you will know what to pick up and what not to. You will not do a copy paste work. A copy paste work does not work. I do not believe in it. I, even as a company, we do so many contracts. There's so many templates, but I have till date, even if the same template, 10 contracts are created on the same day, I check each one by the word, understand the motive behind it, look at the intention of the parties coming along it, check all other criteria, and then I pass it. Because if I pass it, then the organization is trusting me as their lawyer, right? The organization has trust in me, because only after I passes, the finances are checked, the CEO signs it, right? So you, as the legal, you as the freelancer legal, you as the in-house legal, you working with a law firm legal, in whatever capacity you work, but if you are working as a lawyer, you have a big responsibility. Yeah. So you better start learning how to drafting. And for drafting, you have to just understand the basic nature. Then writing down the clauses. Then also, if you pick it up, you will be able to know what's right and what's wrong. You will know what to take in and what to take out. Yeah. So that's about confidentiality. Confidentiality again also has a very, confidentiality is so important that there are times when people do a non-disclosure agreement, and in our business, I can tell you till date, we do not move without an NDA. We, the moment, even if we are in negotiation with businesses, we execute NDAs, because you never know whether you're going to hire that person or you're going to take the services from that person, not know. But when you're doing that in process, that you're speaking about your trade secret, you're speaking about your processes, you're speaking about your information, yeah, which is yours personal to the organization. So an NDA is executed. NDA is non-disclosure agreement, and what it all speaks about is confidentiality. So that is the importance of a confidentiality clause. It appears as a confidentiality clause, and when needed, you also do NDAs, non-disclosure agreements. Yeah, that's how this clause looks like. Not reading it, you guys can check out, there are n number of confidentiality clauses out there. But yeah, since I can see this, do you guys see this? I'll just highlight it for you. Is the screen changed for you? First tell me that. Guys, have the screen changed
No,
for you? Can you
ma'am.
see
We
the
are seeing
example
a
of a
confidentiality clause
No,
slide.
ma'am.
can you see this now? Example of a confidentiality clause.
No, we are seeing
No,
the
ma'am.
yeah, yeah. No, yes, ma'am, yes, ma'am. Now we can see.
You guys can see now, right? Yeah. So I'll read this for you. Can you see B, C here? So A, B, and C. Wait, let me highlight. I'm not able to highlight since it's on screen share. But if you can see my cursor, I'm taking it to A. Can you see this, guys? Yes, no? Some response,
No,
please.
ma'am.
We can
No?
see your confidentiality example class slide. We couldn't see
Correct.
any cursor.
Can you see my cursor now? All right,
No.
not a problem. Can you guys come down to the fifth line from the top, which has a small a in a bracket? 1, 2, 3, 4. The fifth line. It says,
Yes, ma'am.
yeah. So this A, B, and C. There are three such clauses here, which are exceptions to a confidentiality clause. So there are exceptions also, and has to be, because there are times when this confidentiality which you are agreeing to with the other party, it might be needed to be disclosed. And under what circumstances? So one circumstances can be where the government or the law authorities ask you to disclose it, then you are bound to disclose. One such exception can be when the information that you're sharing with the other party under a confidentiality is already out there in the public. And three, when it is some disclosure of such information by law, or it is by disclose to the directors, or you share it within the company, so that it is known to the people who it is supposed to be known. That is three such exceptions which every confidentiality clause will run with. No confidentiality clause can run without mentioning these exceptions. It's a standard clause. That's the way it is written in any agreement you name. Okay? So always remember that though confidentiality clause is binding, it still has three exceptions. Moving further, I have jumped to non-solicit clause. Can you see my screen?
Yes, ma'am. Yes, ma'am.
Thank you, guys. Thank you for responding once and again. I'm sorry, but I don't know why this is happening. So, what is a non-solicit clause? Say non-solicit, you will always hear lawyers talking in this way: non-solicit, non-compete. These are two, I should say, very smart clauses in the contract. Yeah, and again, of course, a contract is binding in nature, so these clauses are binding. So, what is non-solicit? Non-solicit means that you cannot solicit my person. Now, let me tell you. It means, say today you were working with me. I'm a company. You were working with me. Now you are not working with me. But while working with me, you know a lot of my network, right? Which companies I deal with, where do I take if I'm a manufacturing company, where do I take my raw material from, whom do I ask to, prepare the half material, whom do I ask to deliver my goods to the retails, and blah, 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 blah things, right? You know my network. But now you don't work with me. So it can be that you go and work with my competitor. You Till the time you were working with me, you've learned about my loopholes, you know my advantages, you know what I do in the business to become what I am. So here the employee says in the contract that, hey, cool, you don't work with me, that's fine, but we bound you not to poach my people, not to take advantage of my network, or take people out from my company whom you have come across during this period of time while you were working with me. Yeah, this is to protect the business, because if I get into a competitor's business, I might create things which would be lost to my previous company. Yeah, and it is bounded for a period of time generally, that you cannot do it for, say, you cannot do it for a period of time. That's usually there, but that is what a non-solicit clause means, and you will again find it in maximum agreements. I will also, though non-solicit is not written here, but I would like to tell you, non-compete is not here. I want to tell you about non-compete. Non-compete is where you don't allow somebody to work with a competitor for a number of years after they have worked with you. That is a non-compete clause. And today's era is really binding you by non-compete clause. Yeah, because it's very competitive out there. You might, I don't know if you guys might have heard, in the technology side it happened over a few years back, where, and the technology companies do it really very tightly. They bind you by a non-compete for a very long period of time, so that you can't work with their competitors. Yeah, because they all are having the same business. They are in real competition, and even if one person does that, it can be very damaging. So that is how a non-solicit and a non-confidential, non-compete clause works. Force major. This is one of my most favorite clauses, and it became very favorite during the COVID times. Force major means when something happens which is beyond your control. All right. So it can be a war, it can be something like COVID, it can be anything which is major and you cannot control it. So a lot of events. Maybe I'll read it and then I'm not getting the words right now. Yeah. So yeah, war, invasion, civil unrest, labor strikes, yeah, fire, storm, floods. It can be natural causes, governmental or societal actions, or infrastructure failures such as transportation, energy. All of these together forms a force major clause. Till I can tell you for years, this clause was just lying in the agreement. And people used to think, what's the use of this clause? It has never been invoked. Yeah. But look at it. The moment COVID came, this was the only clause which everybody was looking at. Why? Because everything was stopped. Nothing was being exchanged except the essential things, right? So all the businesses which were facing losses, which did not get it goods or services which were supposed to be given by somebody, they were facing some kind of challenge. They were facing losses. Yeah, there were damages around it. So when those companies went to the court to challenge this, and then the government, of course, was analyzing the situation. Then the Ministry of Finance itself came out and said that this coronavirus has to be treated as, you know, uh, an epidemic and pandemic, and it will fall under the category of a force majeure. And that saved so many businesses, because if the force majeure is invoked, you are not bound to do that obligation at least during that point of time, because you are bounded. See, now if there is a war, I'm supposed to give some services to a particular company. How will I do it? In war, how I'm going to do it? And if that person is such a fool that tell you, hey, I want those services, you just tell them, hey, I'm invoking the force majeure. You write a notice, you write a letter, and you say, in this circumstances, it's impossible. Services are suspended. Yeah, that is what force majeure is. So I'll read this. It's from here. An FM clause does
Excuse
not.
me, ma'am. Ma'am, slides have not changed again.
Can you see the force majeure clause?
No,
No,
ma'am.
Okay. Now,
Yes. Yes, ma'am.
Yes.
is it visible?
Yes, ma'am.
All right.
Yes, ma'am.
Okay, thanks. So, an FM clause does not excuse a party's non-performance in entirety. Now, don't mistake it that the person will be out of the responsibility or the obligation to not perform the services or to not perform the work which it has promised under that agreement. It is only suspended for that period of time for which a force majeure has been invoked. It means under those special circumstances, right? So, and it says, I'm just giving you an example. Notwithstanding the punitive provisions contained in the contract of delay or breach of contract, The supplier would not be liable for imposition of any such sanctions so long as the delay or the failure of the supplier in fulfilling its obligation under the contract is the result of an event covered in the force majeure clauses. So, what does this mean? That it will not be put under any damages, it will not be punished for whatever punishment clauses that may be spoken of in the contract for a breach of contract. It will not fall under this criteria. Yeah, it cannot be imposed on the supplier because this is under force majeure now. The obligations are suspended on the supplier for the moment. That is what force majeure clause does in an agreement. Another important clause is governing law and jurisdiction. This is one clause which I have been so strict upon that this is for me a non negotiable. Where you decide, as the lawyer, for whoever you're drafting that contract, deciding where the law would, which law would cover. Of course, if your company is in America, you're not going to say the governing law shall be that of India, right? It's going to be a very expensive affair for your client then. So it has to be America. You see where the registered company is, where the main operations are from, right? And jurisdiction means which city, which state are you referring to? Yeah, basically it should be usually where your client is from. So save the money from there, save the cost for them, save the time for them. Yeah, if you are doing, if there is litigation, or there is a notice, whatever, anything which is legal in nature is come on the client, it will be a costly affair already. And to save their time, effort, and energy, it should be in their particular jurisdiction, in their area. That is what governing law in jurisdiction refers. Let me read this. Jurisdiction refers to territorial jurisdiction of the court of law. For example, in a domestic agreement, one party is.
Slides are not visible.
It now.
Yes, ma'am.
All right. So, jurisdiction refers to the territorial jurisdiction of the court of law. For example, in a domestic agreement, one party is in Mumbai, other is in New Delhi. The parties may agree on the court of Mumbai to have jurisdiction in case of a dispute. Use the word exclusive jurisdiction if you want only that particular court to have the jurisdiction over the matter. Yeah, remember this word exclusive jurisdiction can save you big time. If you do not limit the jurisdiction of the court to a particular state, the principles of jurisdiction under the CPC will play into action. There may be situation where there is overlapping of jurisdiction of courts. Yes, this can happen, which can create a risk for the parties. Time, effort, money will also be lost. Depending on whether the subject matter of the suit relates to immovable or movable property or something else, the suit may have to be filed at the place where the immovable property is situated. That's an example. Or where the defendant resides. This is as per CPC. Or where the cause of action arises wholly or partly. Okay? So that's the rule for doing up the clause of governing law in jurisdiction. Keep this in mind and frame it. Never do it a copy paste, even if you're doing repetitive agreements for the same client again and again. Check with them. Yeah, it's never a harm to check in then deliver. Arbitration clause. An arbitration clause can help you in solving a dispute at your very, I would say at your home. It is like that because arbitration is a complete full form of litigation, but though it is under a quasi judicial body, since it is a more personalized way of doing it, yeah, you can choose your arbitrators, you can choose your place of arbitration, you can choose your governing law, everything. So it's far more easier, and you are also creating a structure before the parties move to the courts. It is always important that as a lawyer, you give your client some structure to, fight out the breach or to fight out a case if there is a dispute has arisen between the two parties. And I always say begin it with negotiation, mediation, arbitration, and then the final thing to the court. Yeah, spare the courts as much as you can, because you know once it's gone to the court, it might be a never ending issue, and it's not the fault of the court. It is us that we are overlading them with so many disputes. So find those alternatives wherein you can, because there are alternatives in the legal system. Yeah, and create that for your client. It will save them. Yeah, we do that. I always prefer negotiations. I prefer mediation and then arbitration and then courts. That way, it can save the company also lack of rupees. The legal department has to be very careful. It should not become a cost. It has to save also. So an arbitration clause is almost always preferable over a conventional dispute resolution clause, which will only specify the governing law and jurisdiction of courts. Wherever possible, the parties will combine arbitration with ADR, that is alternate dispute resolution methods, negotiation, mediation, or conciliation. These are called staggered arbitration clauses, where arbitration is preceded by mediation. It's a called med-arb clause. The contract states if these procedures fail, the dispute will be resolved by the final binding arbitration. If that is the case, these procedures must be exhausted by the parties. A clear notice to start mediation, conciliation, with an opportunity to respond must be provided before the party can issue a notice of commencement of arbitration proceedings under so and so section of the ANC Act. If that is not done, it is possible that the arbitral tribunal will not be. Yeah.
The slide has not changed, ma'am.
Oh, somebody told me it has changed.
Now we can see.
So is it okay if I do it in the short slide? Or do you guys want a full screen? Can you guys see this now?
Yes, ma'am.
All right. Now I've moved it to the next one, which is term and termination. Can you see that?
No, ma'am. They are saying only arbitration clause slide.
Now?
Yes,
No.
yes.
Okay, fine. I got it. There is maybe some problem with my laptop, or maybe some settings which I have to look into. Right? I'm sorry, guys. Is this visible?
Yes, ma'am.
All right. So this is the last slide, and it speaks about the term and termination. What does the word term means? Do you define how long this contract is? What is the period going to be? It's very important. Yeah, never have perpetual contracts which goes on for a lifetime. No, the riskiest thing which you can do as a lawyer is to create long-term contracts. Don't do it. Always call it for a small period of time, review it, discuss it if required, terminate it. Yeah, it will take some time and effort, but it's the best way out. Yeah. Then another part is termination. You have to see there may be termination by way of expiry of the agreement, or it can be for a breach of clause. Yeah. So somebody I asked to deliver some goods, bounded him by an agreement, and they delivered my goods for 6 months. In the later 6 months, they did not. What do I do? For a breach of the agreement of one of the clauses to deliver those services, I call them on for termination. And termination has a procedure. First, you have to write a notice, give them a 30 days period time. You can even give them the period of cure of breach, which is, or you can even extend the agreement for by way of grace period. It really depends on what kind of services, product, what kind of business are we speaking of. Yeah, basis that you form the termination, but it will what just I spoke of. It will just consist of all of these, nothing more, nothing less. Okay, so that's what a term and termination clause does. Okay, so if there is either of these, you should be making sure that the termination is very well defined. Once you define the term, define the termination. If you don't define the termination clause, if you don't write it well, if you don't give it the structure, that the structure will consist of what? That it dies or it's terminated once the agreement is over. One. Other is for a breach of certain thing. Third is we give you also 30 days time period. Fourth is you say, okay, we also give you a cure period. Fifth is you also say beyond the cure period, we also give you a grace period. And apart from all of these, if all of these also are not filled, terminated. Creating such steps and procedures within the contract makes your contract very solid. Yeah. Then the other side cannot come and harp you on points and say, hey, this was not there, you did not allow us this opportunity, it was a bad intention, you had an intention to remove us, take the work away from us, or what not. Yeah, anything, it can go very ugly. But if you create the steps, and the court, for any reason, for any reason that agreement goes to the court, there's a litigation around it. Even when the court sees that such a well drafted agreement has come to them, so many chances were given to the upside, the court will, of course, think of giving a judgment in your favor. That is how drafting plays a role. Drafting is not only about contracts, it is about each clause that you draft. And once you understand the business, once you have seen a few more such clauses in different kind of agreements, you will get the hang of it. Yeah, so that's from my side. And yeah, just split in. I'll speak about the last slide at the end. In the meantime, let's hear from you guys. Shanshu, are you here? We can take the questions if there are any. Guys, if you have some questions, feel free to ask. There's no stupid question. Yeah, there's nothing right or wrong.
Ma'am?
Yeah.
Under the limitation of liability clause, you have mentioned that there are two types of limitations. One is dollar capping.
Yeah.
I couldn't grasp the another type of limitation.
What was the other type? Do you remember the wording?
No, ma'am, I couldn't
One
grasp
sec.
it.
Yeah, let me go back to the slide. Another is exclusion. Yeah.
Exclusion.
Yeah, wait, I'll just explain it to you. I'm running it back to the slide. And the slide says, I'll just read it for you. I'm not sharing it with you guys at the moment. It says, where consequential damages. Yes. So consequential damages are, Sadhna, basically they're special damages. And no contract will take into consideration special damages or consequential damages. Why? Because they are outside the purview of the agreement. The agreements are bounded till this area where it's a direct liability, it's a direct damage, not when it is a special damage or when it is more than what is expected. So when you read about, so how does it becomes more clear? Firstly, this is a standard clause where every clause will speak about non-consequential damages, not consequential damages. And you will understand this more when you start drafting and you understand the business of for whom you're drafting. Because today I am a business, I would like to limit my liability to a certain extent. If I don't give it a boundary and I leave it open to any kind of damages, the other side can come and claim me for anything and everything. That is why, if you go with this, if you generally read the theory part, there are different kind of damages, and under that, consequential damages, which are also known as special damages, are not included in these contracts. Hope I could make you clear.
Yes, ma'am. Understood.
Thank you. Yeah. Anybody else? Feel free to talk, guys.
Is there any questions you can ask? You can put in chat box as well.
Yeah, you guys can put it on the chat box. You can directly talk to me, or come up in the camera. Did you understand? Did this? Yes, Shreya.
Can you please repeat the exceptions to the confidentiality clause?
What do you want to understand?
What exceptions?
The exceptions are 2 or 3, Shreya. One is when the information say you and me entered into a contract. Okay. So there are three exceptions where confidentiality means that we are not going to leak out whatever we've shared, right, during the period of this agreement. But there are exceptions. What? The information that you are sharing is already out there in the public, then I'm not bounded. Two, when there is a notice upon me or some law agency can come and ask me that, hey, share this information, then there's nothing beyond the law and the authority, right? Governmental authority or the state authority or the government, whatever you put it like. And there is one more which says that uh, I I might have shared it, but not with the intention of creating an harm. That is also an exception. So go and have a look today with a few. You will find confidentiality clause everywhere. Go and have a look, and you'll get it more clear. Did that help?
Yes, ma'am. Thank you, ma'am.
Most welcome. Yeah. Who's next? Yes, guys, please fill the feedback form so we know what did you understand. You guys can tell me openly what did you like the session? Did it make sense? Did you grasp something? Did it add value to you? You can write on the chat. And I would also like to tell you that if you like it, you want to have more insights, you can follow me on LinkedIn. I'm by the name of Rachna Shorff. You can follow me on Instagram. I'm with the name Insta Ideas Laws with Rachna. And I would also like to tell you guys that I'm taking a contact drafting 4-week certificate workshop, which will begin from mid-April. Yeah, if you guys feel like you guys can come over and register for it. I'll share the link once we get over this. I'll share it on the group. So Shianshu, Rita, is there anything else?
Excuse me, ma'am. I have one question.
Yeah.
As you've mentioned that to make a good contract, we should practice more. So
Yeah.
my question is, how should we practice? Like, what's the way?
What's the way? Maybe take up hypothetical ideas in draft, or maybe just see 3-4 contracts. Once maybe you see 3-4 contracts, and then you may decide to just draft one without seeing, or you can also uh, maybe I'm sure there will be websites that will give you hypothetical situations and you can think about it and do it. Or maybe you can just think of anything of two businesses and create one. Not a big deal. Maybe I'm thinking it's not a big deal, but or you can also do something like this: pick up one clauses at a time and start building that particular clause. Maybe you start with a confidentiality clause, look around 4-5 samples of contracts, and see how it can be, drafted in various forms. So the meaning will remain the same, but it will give you a lot of idea. Then you will know which technical word to use in which paragraph, which technical word looks far better, how you can structure it. So I think, and that will make your mind start working. So when you will then sit ever to draft, it will not be difficult at all.
Okay, thank you so much, ma'am. That
Most
was great.
welcome. Thank you. Anything else, Rita?
No, ma'am.
Do we have
We are so honored to have you as the chief guest for the evening, and we are thankful to you for sharing your experience and knowledge with us. Hope you all guys learned a lot from our esteemed chief guest speaker. And Legal Specs is presenting an upcoming webinar on freedom of speech, balancing political disclosure and sedition in Parliament and beyond. The speaker will be Mr. Aditya Arora on 9th April at 8 p.m. onward.
Right.
You can connect with ma'am over her LinkedIn, and you can follow Legal Specs on LinkedIn and Instagram. Thank you so much, everyone, for your valuable time and support. And please fill the feedback form because it will remain active till 15 minutes. And
Thank you, Rita. It was great to do this webinar with you guys. Thanks, Shanshu. Thanks, Atray, for bringing me on board. Yeah, it was a pleasure having all of you guys. And I've shared the link. If you feel like, definitely drop in for the workshop or the certificate course. It's going to be great. I promise to add a lot of value. I'll share my last course success story. We did a non-disclosure agreement, and on one of the assignments, which was given by me to one of the students, she posted it on LinkedIn, and the post went viral, which has some around 400 likes and 40 reposts right now. Yeah, so that has given us all the boost that we are doing well, and we look forward to add a lot of value. I'm personally a first generation lawyer, and I would like to add a lot of value to all these young lawyers. Yeah, thank you so much. Thank you, Adya. Thank you, Ayushi. Thank you, everybody. Thanks. Bye.
thank you.